Assalamualaikum warahmatullahi wabarakatuh. My name is Siti Binti Muhammad Noor and my metric number 047744. For the introduction, international humanitarian law refer as the law of armed conflict is the law that regulates the conduct of war. The international humanitarian law is inspired by consideration of humanitarian and the mitigation of human suffering, which seek to limit the effect of armed conflict by protecting persons who are not participating in the hostilities, and by restricting and regulating the means and method of warfare available to combatants. It comprises a set of rules established by treaty or custom that seek to protect persons and property or objects that are or may be affected by armed conflict. IAS shall find its sources in treaties and its customary international law, and its rules set out a series of conventions and protocols. Significantly, the International Community of Red Cross, which is ICRC, as the guardian of IAS. There is two legal mean source must be examined in order to distinguish between international armed conflict and non-international armed conflict. Non-international of armed conflict (NIAC) are determined by Common Article 3 and to the Geneva Convention of 1994 and Article 1 of Additional Protocol 3. That's all.
Assalamualaikum. My name is Amirul Faiz bin Roslan, metric number 046391. As we know, terrorism is a part of an action which prohibits to do towards people all over around the world. In this context, the Middle East and North Africa remain at the heart of global security concerns. Recent years have again seen the rise non-state armed groups resorting to acts of terrorism and the subsequent rallying of a number of other non-state armed groups around them. A variety of factors explain the region's seemingly chronic insecurity and persistent susceptibility to armed conflict, such as governance failures in most Arab countries, the still unfolding consequences of the 2003 invasion of Iraq by the US-led coalition, and the complex relations and rivalries among regional powers. In 2016, at least 7 of the 16 countries in the region used military force in combat on their own territory, and 11 used it on the territory of other countries. States and the United Nations have reacted to these developments by tightening existing counter-terrorism measures and legislation by introducing new ones. Thank you very much.
It is legitimate to take responsive action to ensure state security. However, this appears to be a growing tendency among states to consider any act of violence carried out by a non-state armed group in armed conflict as being terrorist, even when such acts are in fact lawful under international humanitarian law. Some state that recognizing the existence of an armed conflict in their territory will legitimize the non-state armed group that involved. In doing so, it is indispensable to maintain the safeguards protecting human life and dignity laid down in international humanitarian law and international human rights law. The International Committee of the Red Cross (ICRC) has never recognized the existence of any global war on terrorism, nor does it consider non-state actors perceived by some as having global reach.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurhasikin Binti Abdullah. My metric number 046244, and I am from Group 3. So terrorism negates the fundamental principle of humanity, as well as the essential principle and the objective of international humanitarian law, IHL. So in this regard, the International Committee of the Red Cross, ICRC, condemns the act of terrorism irrespective of their perpetrators, be they committed in or outside an armed conflict, and is deeply distressed by their devastating impact and on communities and individuals. And next, cities are reduced to rubble. Civilians are directly attacked, humanitarian and medical personnel, transport and infrastructure are targeted and prevented from fulfilling their function. The civilian population is deprived of supplies essential for their survival through warfare, humanitarian access to deny, and resulting from all of this, hundreds of thousands of people are internally displaced or have fled to their country, leaving a home, a job, a plot of land, or ever close relative behind. So in this absence of political solution, compliance with international humanitarian law, IHL, and the more fundamental values underpinning this body of law are required more than ever from all sides, because prohibition of acts of terrorism and the other violation of the law are not just binding on non-state armed groups. That's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Izzati Binti Hilmi, metric number 046374. Okay, so now I would like to discuss about the IHL applies only in situation of armed conflict. So, what kind of armed conflict that we can apply international humanitarian law? First of all, under IHL, it offers two systems of protection. The first one is the International Armed Conflict, IAC, which occur when one or more states resort to the use of armed force against another state. Alright, and then IAC also happen when armed conflict between a state and international organization occur. Alright, this IAC also known as wars of national liberalization. Why? Because liberalization means people are fighting against the colonial domination and alien occupation and against racist regime in the exercise of their right of self-determination are classified as IAC under certain conditions. The second protection under international humanitarian law is the non-international armed conflict, also known as NIAC, which occur when armed conflict in which hostilities are taking place between the armed forces of a state and organized non-state armed groups or between such groups, reaching a certain level of intensity, and the group involved must be sufficiently organized. According to Common Article 3 applies that to armed conflict not of an international character occurring in the territory of one of the high contracting parties, and the second one is under responsible command exercise such control over a part of its territory as to enable them to carry out sustained and concerted military operations. That's all. Thank you.
Okay, in ICRC's view, the international community must be clear and firm on the need for counter-terrorism activities to be conducted in full respect and of the protection afforded by all individuals by international law, in particular IHL and human rights law. Counter-terrorism norms may interfere with IHL's regulation of armed violence, notably by prohibiting conduct that is not unlawful under IHL, creating legal confusion and potentially adversely affecting some of the underlying principles of IHL. Another crucial question relating to IHL applicability is whether non-state armed groups designated as terrorists fulfill the organization fulfill the organization criterion for classifying a situation as a non-international armed conflict in general applicability of IHL to a situation of violence in which such fighters may be engaged does not depend on the nationality of those fighting. It depends only on the facts on the ground and on the fulfillment of certain legal conditions stemming from the relevant norms of IHL, in particular Common Article 2 and 3 of Geneva Convention. In other words, in situation of armed conflict, IHL will govern the actions of foreign fighters as well as any actions against them by parties to that conflict when such actions have a nexus to the armed conflict concerned. In this regard, it is important to underline that in relation to an armed conflict to which the detaining authorities are party must benefit from the protections afforded by the applicable IHL rules, irrespective of the domestic laws that also govern their detention, but seems that states dealing with this phenomenon tend to shy away from recognizing the applicability of IHL to their detention.
Assalamualaikum, my name is Nadira Zailan, my metric number 047858. Today I would like to talk about the limitation of international humanitarian law. So the IHL itself consists of the limitation to deal with the dispute between non-international armed conflict. So one restriction is that counter-terrorism is allowed under international humanitarian law, but with the exception does not violate the human right of citizen. So IHL prohibit expressly certain activities which are criminalized as terrorists under legal structure. However, in legal term, armed conflict are considered lawful and other acts of violence are illegal, while any act of violence classified as terrorist is always unlawful. So it is also clear that the parties to a dispute are allowed to target one another's military objective or individual who are not entitled to the protection from the direct attack. So the international humanitarian law did not prohibit violence against this target, whether committed by state or by non-state party. So this concept therefore represents the inability to deduce the validity of the cause pursued by the belligerents under international humanitarian law. And lastly, for the conclusion, the ICRC and other humanitarians use a range of legal instruments in their effort to promote the observance of humanitarian law by parties to non-international armed conflict in disseminating and training practice that are necessary for making known the rules of IHL and for establishing the basis of discussion concerning respect of law. So these two do not guarantee greater compliance, but nevertheless provide a basic for legal advocacy and responsibility. So the ICRC has adopted a case-by-case approach for analysing and legally classifying the different situations of violence with respect to the various armed conflict and numerous counter-terrorism measures at the national and international level.